Hey, welcome back to Sidebar Social. I'm Dana Stewart.
And I'm Jennifer Grinke.
Okay, so today we're going to talk about your favorite subject.
Shopping?
Money.
Oh.
Yeah, well, which requires, shopping requires money.
Okay.
So
So
specifically in the family law world, we're going to talk about child support.
child support.
Yeah,
Fun.
lots of questions, lots of, I think, incorrect information out there, through our ChatGPT lawyers we deal with now. So let's kind of start off high level. Okay. How do we figure out, or how does a judge figure out a child support amount? Let's kind of talk through the guidelines in the family code. Can you speak a little bit about that?
Yeah, so basically we have caps on our child support. Some states do not have caps. I would say we are one of the states that has the lowest child support amounts. Would you agree with that?
Yeah, agreed.
A lot of states will look at both parties' incomes when they're determining child support, but in Texas, we only, for the most part, unless we're doing what we'll talk about later, is an offset. For the most part, we're just going to look at the person who's paying's income. We're not going to look at their spouse if they have a new spouse, other people in the household. We're not going to look at the ex-spouse. We're just going to look at the person who's paying. And so can you talk a little bit about the caps that I brought up? Like, what do we have in terms of child support caps?
Yeah, so what Jen's referring to is in Texas, whether you or the person who's paying child support, our cap is $11,700 right now of your net resources.
Yeah, so basically that's the max net resources they can use when they determine the child support amount, unless there's special circumstances.
Right. So in theory, whether you make $11,700 or $25,000, child support will only be applied to that first $11,700, right? That's what you're referring to with the cap.
Mm-hmm.
And so what that looks like, the family code we've got our percentages that we look at when we determine how much of that $11,700 or whatever amount between 0 and $11,700 should somebody pay. And it depends on the number of kids. So can you give a little bit of information on that?
Yeah, so if you have one child with that person, then it's 20% of that monthly net resources up to the cap. If you have two children with that person, it's 25%. And if you have three, it's 30%. And then there's also discounts given if you have other children, not with that person who you're in the case with for the child support, but with another person that you're obligated to support. So in those situations, you need to inform your attorney, or if you're going through the attorney general, about your other children so that you can get a discount taken off your child support, because you have to use your resources towards other children in your household or that you're obligated to support.
And so we're talking monthly resources here.
Yeah.
And that's actually a really good point. It's a pro tip. So I had a client once who came to me. He had 3 different children with 3 different moms, and he was paying 20% to each of the moms.
What did he have left?
Almost nothing. That's what it was not a good situation. And so the point that Jen was making is, if, let's say you're going through a custody case, divorce, and you have a child with that parent, but you also have another child from a different relationship, you can get a discount on the amount you're paying for each child based on having another child that's not involved in that case. But this guy didn't know it, so 60% of his income was out the door each month going to 3 different mothers of his children. And as far as let's kind of break down for the audience how we get to what the net resources is. Let's start first with gross, because we're talking about income, but it's not just income, it's resources, right? So can you explain a little bit about that?
Yeah, so when we're determining what the net resources are, we'll take that person's gross income and we'll take out for taxes and Social Security, but we will not take out for things like if somebody has their 401k they're withholding, that does not get taken out. So that would not be part of net resources, or that would be part of net resources. That would stay in the amount. There's other things that matter if somebody's self-employed.
Yeah, or for like union dues for people who still have those.
Railroad
but the point being, the railroad dues. What we do is we're going to look at how much do you have coming in each month. There's those federal withholdings that we're going to subtract out. And then if you're paying for health insurance for a child, we subtract that out. Whatever's left, that's your net resources. But I think what's an important distinction is a lot of people will say, oh, hey, I'm self-employed. I make $2,000 a month. And then they want to pay child support off that. But talk a little bit about how, if they're running a bunch of expenses through their business and kind of concealing income, what can happen there?
Yeah, so I feel like that's where it gets kind of tricky because then we have to do a deep dive into that person's finances. So, for example, I think you had this situation one time where the person's like driving a Mercedes, like lives in a big house, their mortgage is more than they claim their gross income is every month. And so, typically, one thing that we suggest doing is hiring a forensic accountant and going through their bank statements and trying to get the court to impute their income up to a higher amount so that you can gain access to more money for child support.
Yeah, and that case, I think it's the same one you're talking about. So in that situation, the person paying child support represented to the court that they were paid $500 biweekly, and that's it. And they were self-employed. And my client told me, I know this person makes a lot more than that. So the judge set child support at a temporary hearing based off the $500 every other week pay, because that's the only proof we had at that time, or that's all the documentation. We then gathered a bunch of discovery through sending out, subpoenas, different things, got a bunch of bank statements, tax returns, realized the money coming in and out of those accounts each month, he was spending in excess of $20,000 a month on bills. So the court deemed that to be his resources, despite the fact that his income was only $500 every other week. And so that's a really good point you're bringing up.
Yeah, and these caps really make a big difference on child support calculations. I've had situations where there was a fight whether the child support was going to be calculated under California in California or in Texas under Texas law. And the difference was like $10,000. So it was going to be $10,000 more in California than it was going to be in Texas. And that's because we have these caps.
Yeah, people are often shocked at how, well, I guess depending on which side, whether you're the paying or the one that you're receiving child support, but generally people that are receiving it feel like our state mandated figures under the child support guidelines are too low. They're not enough. The cap that we keep referring to, that does increase every 6 years to adjust for inflation. So back when I started practicing years ago, I think the cap was like $4,500. Now it's up to, $11,700, but still there is that limit. And if you do have a case where there's multiple jurisdictions, or if you've got an option of where you're going to file, definitely worth consulting with attorneys to figure out which one's going to be more advantageous to your situation.
We talked a little bit about that's the cap, but that you can go above the cap. What can you explain, like what types of situations would a judge, or what type of evidence would you have to show to a judge to get your child support above the cap?
Good question, and one that I feel like we've seen a lot. So if you have a child that has special needs, and so if you can truly show to the court that, hey, my child's needs, maybe they're autistic and they're in ABA therapy, they may have occupational therapy, they've just got a bunch of different providers they work with, and their expenses vastly exceed what the child support amount would be. Well, you can bring that evidence to court and show that to the judge, and the judge has the ability, if the judge believes it's all legitimate, to then order child support that would be in excess of those cap amounts.
Okay, so if your kid's used to having like a nanny, a private jet, like a private tutor, wearing some designer clothing, can you come to court and say, this amount is not going to be enough to sustain my child's lifestyle once we get divorced?
Can you? Yes. Is it going to go anywhere? I think that depends, right? So in a situation where maybe the people that are going through the divorce are very affluent and they've had this lifestyle, it's potentially a judge may say, I'm going to order above the guideline child support amount. Or the judge may say, I'm going to order that one parent, maybe the one that has more resources, pay for the vehicle or pay for extra, like if there's private school, so it may not be direct child support, but the judge or the court can order additional expenses be paid above that child support amount. But have you made those arguments in court?
No, I think in most situations, lifestyle is not a reason to go above the cap. But I understand, like if someone has private school or something like that, the judge might continue making somebody pay that. Follow us and join the conversation on Instagram and YouTube at Sidebar Social.
Question we get a lot. Can the person paying child support find out or get receipts or an inventory of where the child support money went?
No, we get asked this all the time. They want an accounting of what the money is being used for, and they want to know what the money is used for or what it can be used for. And so basically, the person receiving the child support can use it for whatever they want, with the understanding that that person still has to pay their mortgage or their rent. They still have to feed the child. They still have to clothe the child. The child's still going to have a bunch of monthly expenses. And so, no, you do not get an accounting every month of what your child support has been spent on.
Okay, another question for you. The person who's paying child support, if their order just says you pay X amount a month, we'll say $2,000 a month for child support, does that parent paying support also have to pay for extracurriculars, pay for school supplies? How does that work?
No. So unless the order specifically states that they have to make these other payments, all they're obligated to pay for is whatever they incur during their time with the child plus the child support each month.
Right. And I think for a lot of people, they're like, well, it's not enough. It doesn't cover it.
Yeah.
But it does open the door to the discussion that if you're going through a situation, yes, we have these guideline rules that the courts will follow, but there's nothing precluding parents from coming up with their own agreements.
Yeah, so we have a lot of people, especially extracurriculars. I know they're so competitive these days, and the fees, can outweigh what the monthly child support is. And so I know we have a lot of people that will agree to split those expenses or pay a certain percentage of them to make sure that the kids can still remain in the activity.
Okay, so another question for you. Seems like now 50-50 possession is a pretty common, like it's become I think, more common. Does that mean no one has to pay child support?
So no, it does not. I think the most common thing we see in those situations is what's called an offset of child support. And so the court or the attorneys are going to calculate under those guidelines we talked about what one parent would pay the other and vice versa, and then they're going to subtract the two. So if one parent would pay $1,000 and one would pay $2,000, then the other parent would have to pay $1,000 to the parent who had the lesser child support amount, and that was my understanding is just to equalize the two incomes in the household. But the judge can really do whatever they want in the 50-50 situation because it's not in the family code.
Right.
So we see the offset. We see no child support being ordered if the parents have relatively similar incomes. And then we'll also see where it's like, okay, you want half the time, but you make so much more money, you still have to pay the full guideline support to the other parent.
Yeah, and I've heard judges say in that last example where it's 50-50 possession, but one parent makes vastly more, that it's not a true equal plane that they're on financially. And so, yes, even though you have equal time with the child, if parent A is making 3 times the money, they may still be ordered to pay full child support. So how do you deal with the parent who is the one paying child support and is pissed about that, right? They're like, hey, I have 50-50. Why should I pay child support? Like, take us behind the curtain. How do you deal with that?
I mean, at the end of the day, the money is for the kids. And like I said earlier, the kids still have those expenses at the other parent's household. And so just trying to reframe it for that parent that you can't think like, oh, I'm giving this money to my ex-spouse and they're out shopping or they're out doing whatever they want with it. Your kids are still at that house and they still have expenses over at that house, and you want to provide for them, regardless of where they're at. So while they're not at your house half the time, they still have just as much expenses.
Right. So it's kind of asking the client, well, do you want them to not have a place, their own room to live in when they're with their other parent?
Do you want them to have clothes? Do you want them to have activities that they can go to?
Yeah. And then if they continue to say, I don't care, then we send them to a counselor.
Yeah.
Yes.
Okay, Dana, so question for you. You've been asking me a lot of questions today.
It's kind of fun.
What if down the road your ex starts making way more money and you want to go back to court and try to increase your child support? How would they go about doing that?
Right. So when you get a court order, it's a final order, but it's never really permanent. It can always be modified if there is a situation that warrants it. And so in that example, let's say that you're receiving child support, your ex is paying it, and now you know that sometime after you got divorced, now they're making double the money, or it doesn't have to be double, but just in this example, they're making a lot more money now. And so you're wondering, hey, can I go back to court? And the answer is yes. You can file a petition to modify your prior order, asking the court to look at the financial situation and then essentially use those child support guidelines that we talked about to now run the numbers based off that person's new resource level, whatever that might be. So yeah, you can modify it. What was your other question? You gave me a compound question, so I didn't remember the second part.
I think I was just asking you how they do it and when they can do it, or...
Yeah, so generally speaking, well, we've got the family code will allow every 3 years for a child support review. So somebody could actually go through the attorney general to then say, hey, it's been 3 years since my last order was entered. And then we can look through that, or the OAG, the attorney general's office, can actually look through that, or you can go to a private attorney and they can essentially run the numbers. Now, where it can become a little bit tricky though, is if you think your ex is making more money, but you're not really sure. Right.
Yeah.
And so in one of those, you may open a case file because you believe they're making more money. But if you're not 100% certain, there's a chance the support amount could actually be decreased if it turns out that all the income information shows they're making less money than what you thought.
Yeah, so basically every 3 years, it's an automatic increase or decrease if it differs from $100 or 20% from what they're currently paying. And that's only if your prior order was under the guidelines. So if you guys came up with your own child support amount, you can't then use that automatic rule. And so if you're not using the automatic rule, then that's basically what Dana was talking about. You have to be able to go in and show there's been a material and substantial change in circumstances, like somebody has a lot more income or a change in lifestyle, so that you can get the child support increased or decreased.
And it could also be the other way. It could be that a person lost their job. We saw that a lot during COVID, right? Lots of people were being laid off. And so people were having to go back and change their order to adjust. But tell the audience what happens if you don't change and you're just not paying the child support.
Yeah, so if you don't change and you're not paying the child support, or you're paying some version or reduced amount, then that's when you can get in trouble with the court. If an enforcement's filed against you, you could be facing contempt. So you can be facing time in jail or monetary fines. You can get admonished by the judge. I think it's important to note too that you can't agree with your ex or the person that you're paying the child support to reduce your child support or increase it without an actual court order. So if you agree with your ex to reduce your child support and then you've been paying $500 less for 6 months, the court and the accounting system through the attorney general is still going to have it as if you had the higher amount, so you can still get in trouble with the court.
Right. I think it's a good distinction because when it comes to changing possession schedule,
Yeah.
parents can, and courts even encourage, in fact, every order states parents can agree to do essentially what they want when it comes to possession. But what Jen's saying is if the parents get together, hey, I lost my job. The other parent says, fine, just pay me $200 now instead of $1,000. Well, the state doesn't know that. The OAG doesn't know it. They think you're still on the hook for the $1,000. And so you actually have to go through the formal process to get it changed. Otherwise, you're facing potential jail time, like you said.
Yeah, and I've had a lot of those where it's just a big mess, and then you owe $100,000 even though you've been paying what you had agreed to pay, but that person can renege on their agreement. And so most orders will have something in there that says, it's only what it says in the court order. It's only the amount in there and what we go through with the state disbursement unit or the attorney general, so that we try to avoid those issues.
So just to piggyback off what we were just talking about with that enforcement, for those that are watching, if you don't pay your child support when it's due on time and you end up in court with an enforcement, and if you get found in contempt of court for not following that court order, not only you can go to jail, yes, but now the way it's set up, I think the system is a lot better at protecting for people who are entitled to support that don't get it, because if you as the obligor, the one ordered to pay, you do not pay, you cannot renew your license. They can actually levy tax, they can essentially levy your tax returns or bank accounts. Passports. There's all kinds of ways now, if you don't pay your child support, that the state can intervene and
either take it from your retirement.
Yeah, so they can make your life hell till you pay. So the point being, if you're in a situation where you think if you're paying child support, your income has changed for the worse, you're making less, you should consult with an attorney pretty quickly to talk about the options of potentially filing a modification.
To learn more about Grinke Stewart Family Law, visit GrinkeStewartLaw.com.
Okay, Dana, let's do some myth busting.
I love it.
Okay, so if my ex gets remarried, and let's just say they marry a really wealthy person, does that person's income get factored into my child support calculation?
Your ex's new spouse?
Yes. True or false?
That is false. It does not get calculated into it. So when setting child support, the court's going to look at just the other parent. So your ex would only be the one, that income is what we would be looking at to calculate child support. Kind of a little caveat to that, though. Let's say that your ex then decides, I'm going to quit working because my new spouse is very wealthy. Now we can get into what we talked about before of looking at what is that lifestyle and what money's coming in and out of accounts. And even if your ex isn't actually working, but rent's being paid or the mortgage is paid, car insurance, car payment, those are resources available even if that person's not working. So then the court could deem some amount of money coming in for child support purposes. But generally speaking, the new spouse is not included.
Okay, next myth. If I don't see my child, I don't have to pay support.
That's not true. That's a bad plan, actually. It's a really bad plan.
Why should I pay for something I can't see?
I get it and I understand it, but we've got to think about it from a rational perspective. And so if you are not able to see your child, but you have a court order that says, every other weekend's your weekend, but your co-parent will not let you see the child, that does not absolve you of your financial obligation to pay child support if you were court ordered to pay it. So if you are not getting to see your child, get in contact with an attorney and talk through what we were discussing earlier, a potential enforcement action on how you can go about trying to get the rightful possession that you were court ordered to have, but pay your child support.
Okay, so the final myth, we get this one a lot. If my ex is not paying me child support like they're supposed to, I do not have to let them see the kids.
Okay, so also wrong. It's the inverse of that situation we just talked about. So if you are entitled to receive child support, but your ex doesn't pay it, you do not have the legal right to then say, well, you cannot see our children. Same concept that if you withhold the children, just like the other person not paying child support, you're both violating a court order. You can both be held in contempt and you could both go to jail for that. So also a bad idea. Child support can be a very touchy subject.
Yeah,
and we have a lot of clients, they get upset about it. And I know you mentioned you try to reframe it sometimes for the client to say, hey, remember, your child has to go to this other parent's house and you want them to have a room and things, stuff to eat, things to go do, clothes to wear. But if your client continues to struggle with that or they're just not able to move past it, what are some other resources that you'll use to help them kind of work through those feelings?
Yeah, so we definitely can send them to a parenting coach or a divorce coach or a therapist to kind of talk through some of the blockage behind like why they do not want to do this for the children. Other things we've done, if you can get the other side to agree to it, is to rewrite it, maybe not as child support, but to write it as, a payment towards certain things individually, like the activities, schooling, whatever it is, clothing. So sometimes that solves the problem, but that's just a little bit harder to get everyone to agree to.
Right, meaning so instead of the order saying ex-husband pays the ex-wife $1,000 a month in child support, you're talking about rewriting the order to say ex-husband will cover the first $200 of extracurriculars every month and pay for a higher percentage of medical costs. Right.
Yeah.
That's creative. And then there's also parenting classes too, right? That we can send them the parenting classes. But I kind of feel like parenting classes can be good, like the online ones. I don't know. I feel like you need that maybe in conjunction with some in-person counseling.
Or we can just send them to court.
Or you can go to court, right? But then only the lawyers win. So people at home, going to court is not necessarily what you want to do unless it's a last resort.
Child support can sometimes be a difficult conversation because it involves and ties your kids to money. We understand that. And so we've come up with some frequently asked questions regarding child support, and you can find those on our website at grinkestewartlaw.com.
We'll see you next time on Sidebar Social.